Hey, everybody. Welcome to this impromptu Law Self-Defense live show to cover the Michael Barisone verdict. I'm sure you've all heard the news, but now's our chance to talk through it. My apologies for being a couple minutes late. This was not a planned event, obviously, and I had some existing obligations I had to get out of the way before I could jump on here. So come on in, make yourselves comfortable, and we'll discuss what happened. Before we get into that, I've been getting a number of inquiries. I see one here from CRJR as a super chat. Thank you very much, CRJR, for your support. He asked me if I'm going to follow the Hannah Payne trial. It starts Monday the 18th. My understanding was it didn't start till June. The last I saw was it wasn't starting until June 6th. So I'll double check. If it's happening June 6th, I will not be covering the trial because I have other obligations for that week and next. In full frankness, I'll be on a motorcycle trip down to Vegas that week. So that's where that is. If it's happening next week, I suppose I could jump on it. We'll have to see what happens, but that's not my expectation. It starts Monday the 18th. That would be 2 months earlier than I'm aware of it starting. But if it's starting this coming Monday, I'll certainly take a look. Last I heard, though, is that it had been delayed again until June, first week of June. So come on in, folks. Come on in. Grab a seat. As soon as we get at least a couple hundred people in here, we'll start with the substance. By the way, for those of you who may have been following my most current fitness journey over on Instagram. I am on Instagram. We're on all social media. You can find us wherever you go at lawofselfdefense.com/whatever the social media is. On Instagram, go to lawofselfdefense.com/Instagram and you'll find us there. We don't do a ton there. That's as it may be. Maybe I'm just too boomerish for it. But just about a little over a month ago, I started on my weight loss regimen at 222 pounds. And this morning I was down to 206, even. 206. So I'm pretty happy with that over a month and 2 days of time. So looking forward to continued progress there. For those who wonder what I'm doing to lose that kind of weight in such a short period of time, it's really straightforward. It's intermittent fasting. So I don't eat till 1 o'clock, stop eating by 9. It's caloric restriction. So I only eat about 1,000 to 1,500 calories a day. And then I exercise between 800 and 1,000 calories a day, mostly on a treadmill. Today, I did do a 5-mile hike for a little change of pace, and that works for me. I'm not a nutritionist. I do not recommend this method for any of you. For all I know, if you did what I'm doing, you would die of a heart attack 5 minutes in. So please do not follow fitness or dieting advice for me. I'm just sharing what works for me. Hoping to be below 200 in a week or so and shooting for somewhere in the 190 range, which is still a little heavier than I probably ought to be, but there you go. All right, folks. Yeah, score one for table founding, perhaps. All right, we just broke 202. Let me pull up my little intro video here. This is a little impromptu, folks. I'm going to try to pull up the actual reading of the verdict. I believe I have that more or less spooled up so we can share that and capture that. If for no other reason than just for the record. My cameras are all doing some reorganizing in the office, and a lot of my lighting and camera stuff isn't quite where it should be. Let's see, a little better. So let me do my little show intro video, and then I'll hop back here with all of you. Here we go. And we're back. All right, folks. So this is the Law of Self-Defense show to cover the verdict in the Michael Barisone trial. A quick recap of that trial, what it was about. Michael Barisone was a former Olympian in the sport of dressage. That involves horses. The horses walk in funny ways, and I guess both the horses and the riders need to be trained in this arcane art of horse riding. He was an expert at it. He had a horse farm, horse ranch, whatever you want to call it, horse facility in New Jersey, where he taught others, both the rider and the horse, how to do dressage at a high level. Apparently, he was very well respected in that dressage community, as one might expect from a former Olympian. Lots of students loved him. One student, unfortunately, he had a serious problem with, and this was Lauren Kanarek. Lauren Kanarek was in her 40s when she connected with Michael Barisone. She wanted to learn the art of dressage, believed he would be a good instructor for her. She was invited by Michael Barisone to live on his property and stable her horses there. So she became a resident of that property with all the rights of a tenant living someplace under New Jersey law. She brought with her, by the way, her boyfriend, Robert Goodwin, who appears to me to be rather a ne'er-do-well living off of her. She rather appears to be living off her daddy's money. Not sure exactly what's going on there. In any case, the relationship between Lauren Kanarek and Robert Goodwin, the boyfriend on the one hand, and Michael Barisone, the farm owner on the other, became extremely toxic. She basically set out to destroy him. I mean, she had no difficulty or hesitancy conceding to this on the witness stand when she testified. She hated him and was set out to destroy him psychologically, emotionally, mentally, reputationally, professionally. She was putting the most vile things you could imagine on social media at length, extreme detail, much of which apparently was simply untrue. Her position appears to be that social media is made for shit talking, so she was going to shit talk Michael Barisone. That's what this Jersey girl was all about, and she did. She called local town code authorities to do inspections of his property where they found faults. Effectively got him kicked out of his own house because of some code defects in the house. He was living on a mattress on the porch of his barn, is my understanding, at the end there. And she broke him. She broke Michael Barisone. If you see images of him from a year prior, I should say 10 years prior, he presents as a very good-looking, physically fit, charismatic, confident man, skilled at his trade, proud to do a job he loves, just a guy you would respect just on first appearance, first encounter. When he was in court, he was obviously a horrifically broken man, long hair, making odd facial grimaces, clearly someone who was psychologically and mentally broken. At least he was certainly presenting that way in the courtroom. And there was eyewitness testimony of him devolving into that state over the course of his interaction with Lauren Kanarek and Robert Goodwin. In any case, the relationship became so toxic that ultimately Michael Barisone approached Robert Goodwin, the boyfriend, said, "Hey, can't we settle this? I don't want us to go to war." Robert Goodwin said, "Look, there's already lawyers involved. Let the lawyer settle it." Goodwin was walking away. When Kanarek pushed past him towards Barisone, she apparently had just, it appears falsely, reported to the New Jersey version of Child Protective Services that Barisone was sexually molesting his own girlfriend's daughter. This appears to be a completely false accusation, but was enough to flip Barisone completely. He pulled out a semi-automatic pistol, shot Lauren Kanarek twice in the chest, a shot at Robert Goodwin, missed him, but shot at him. Thereafter, he was subject to a physical beating by Robert Goodwin until police arrived. Obviously, Lauren Kanarek survived the 2 gunshot wounds to the chest. She is alive today, testified at trial. But the shooting of Kanarek and the shooting at Robert Goodwin would result in 2 attempted murder charges against Michael Barisone. And he also faced a unlawful possession of a gun for unlawful purposes under New Jersey law, which by itself is good for 10 years in prison. And attempted murder, normally if you're convicted of an attempt crime, the punishment is the same as the underlying crime. You're not given a break for your failure in achieving your goal, your failed attempt. So he was potentially looking at life in prison on the attempted murder charges, or whatever the sentencing for murder would be under New Jersey law. The states vary on this, and I don't claim to have particular expertise in New Jersey sentencing law. But for purposes of discussion, let's imagine it's life in prison without possibility of early release, which would be typical for a murder or attempted murder conviction. Now, Barisone had been offered a 10-year plea early on, which is pretty much what he was going to get for the gun charge. I mean, there was really no contesting that he was in unlawful possession of the gun under New Jersey's fascist gun control laws. So it seemed for sure that really he had no defense to that. In fact, at closing, I don't recall his defense counsel mentioning the gun charge at all on closing. I mean, made no argument about it, to my recollection. Spoke only to the actual use of force event itself. And so that's what he was looking at: 2 counts of attempted murder and the 10-year gun charge. Now, the defenses here were varied in theory. There was 2 possible perfect defenses that could lead to an acquittal. One of the perfect defenses was self-defense. Unfortunately, there was no evidence in the trial that Barisone was facing an imminent threat of death when he shot Kanarek and shot at Goodwin. There was no evidence in that. He himself said he could not recollect what happened in the minutes immediately preceding and after the shooting. So even he couldn't say this is what made it self-defense. And in the absence of him meeting his burden of production on self-defense was not in play. And there was no self-defense jury instruction given to the jury. So that perfect defense, which is successful, would lead to an acquittal, no criminal liability. The use of force simply is not a crime under that circumstance. That was off the table because of lack of evidence to support it. The other perfect defense was insanity defense. Insanity defense is a very high threshold. Unlike self-defense, which is a justification defense, insanity is an excuse defense. The outcome, what you did, is not deemed good or justified, but it's excused because of your insanity. And unlike self-defense, which the state has to disprove beyond a reasonable doubt once the defense meets its burden of production, the insanity defense, the burden of persuasion remains on the defense. The defense has to prove insanity by a preponderance, a majority of the evidence. And frankly, I saw nothing in this trial that rose to the threshold of a genuine insanity defense. Normally, an insanity defense is you have to not be able to tell the difference between right and wrong. You have to think you're not shooting a human being without justification. You have to think you're shooting a robot or a werewolf or a Martian or a witch, maybe. And I didn't see any evidence that he was that disconnected from reality at the moment he fired those shots that an insanity defense would apply. There were what are called imperfect defenses. Imperfect defenses are defenses that cannot lead to an acquittal, cannot lead to, in the case of an insanity defense, by the way, you're acquitted on the criminal charges, so you don't have any criminal liability. You don't go to prison. But normally you're also not released. You're institutionalized in a mental institution for some indeterminate period of time until the doctors there determine you're no longer a risk to others. Then you may be released, but that could be weeks or months or years or forever. It's up to the doctors in that institution. But still, under insanity, no criminal liability. Then we have the imperfect defenses. Imperfect defenses cannot lead to an acquittal, but they can mitigate what would have been murder down to manslaughter. One of those might have been imperfect self-defense, where you had a genuine, subjective, good faith belief in the need to act in self-defense, but that belief was objectively unreasonable. It was irrational. Frankly, I thought that was a pretty good fit for the evidence here. Clearly, Barisone was emotionally and psychologically destroyed by the way he'd been treated by Kanarek and by Goodwin. That's not a justification for shooting them. You don't get to shoot people just because they've been assholes to you. You might wish we lived in such a world, but we don't. But that imperfect self-defense, that subjectively genuine but objectively unreasonable belief to act in self-defense, can mitigate what would have been murder to manslaughter, or in this case, what would have been an attempted murder conviction to an attempted manslaughter conviction. It's still a manslaughter sentence. You're still going to prison. But whereas murder might be life without possibility of early release, manslaughter is typically something like 10 to 20 years. And you may be eligible for parole in a third of that time in some states, more in other states, but at least it's not forever. Another closely related in terms of underlying legal principle, imperfect defense would be diminished capacity, that the psychological stress he'd been put under by Kanarek and Goodwin diminished his ability to form the intent necessary for murder. Again, that doesn't get you to acquittal, but it could mitigate murder to manslaughter. Frankly, I thought those were the two most likely prospects, but the defense here seemed completely disinterested in either of those, didn't really argue to either of those in closing, only really argued insanity defense, which I thought was quite a stretch. The fourth possible defense is not really a legal defense. It's more of an emotional pleading to the jury, basically telling the jury, hey, listen, we can't really justify what our client did, legally speaking, on the merits as self-defense. Maybe he's not really insane to the threshold required by the law for an insanity defense, but look how these people treated him. Look what they did to him. Look how they broke him. completely, so, and intentionally, not accidentally. I mean, they set out to do this, to break this man, and they were successful. They broke him, and therefore you should acquit our client or mitigate the sentence to some lesser included from attempted murder, just because of how bad these people treated him. Now, that's not a legal defense. That's an emotional defense. And there was a distinct possibility here. I mean, Kanarek and Goodwin come across as completely vile, monstrous, horrible, toxic, nasty people, for sure, at least within the context of their treatment of Michael Barisone, for sure, which is really all we know about them through the course of this trial. So those are the possible defenses against those criminal charges. What actually happened? Well, it appears what actually happened is that the jury returned a verdict on the 2 attempted murder charges of not guilty by reason of insanity. So what happened there? Do they really believe that he was insane to the legal definition of insanity? Or was this really that 4th legal defense, the legal defense that's not a legal defense, the emotional pleading to the jury? Now, they took a couple of days to get to this verdict. So obviously there was a lot of discussion and debate among the jurors. They didn't immediately come to a verdict. They did ask questions of the court about specific dates of when psychological experts met, different psychological experts, some for the state, some for the defense, the dates on which they met with Barisone, I guess, to try to assess the credibility of their assessments. As you might imagine, the state expert said he wasn't insane legally. The defense expert said he was insane legally. That's how these things typically go. And one can't help but suspect that the jury really went with the 4th rationale, the emotional pleading, that, listen, maybe what this guy did wasn't really justified. Clearly it wasn't justified, and self-defense wasn't on the table. They weren't given a jury instruction on self-defense, and really legally it probably wasn't excusable as insanity, but they did this to him. Kanarek and Goodwin broke him to the point where he engaged in this conduct. The Michael Barisone of 10 years ago would never have done this, not in a million years. They intentionally drove him out of his mind, his reasonable mind, to a point where he simply was not making rational decisions. Maybe not insane decisions, but not rational decisions. And the reason he wasn't making rational decisions wasn't because he'd become a drug addict or something like that. It was because they did this to him. And we're not going to send him to prison for much of the rest of his life because they did this to him. We're just not willing to send him to prison. Now, there were probably some people who would say, listen, we just want to acquit him. We don't have to give an explanation for why we acquit somebody. Nobody knows what happens in jury deliberations. I don't have to explain to anybody how I came to a verdict. I'm just going to vote not guilty. But obviously not every juror felt that way, or it would have been not guilty an hour after they went into the deliberations. Some of the jurors probably felt, well, no, I'm not going to vote not guilty, because then this guy is just back out in public. And he did shoot a woman twice in the chest without legal justification, and shoot at another guy. And it's only by the grace of God that those 2 people, however monstrous they might be, it's only by the grace of God they're not dead. And the law does not say he had the privilege to kill them or attempt to kill them. So I'm not simply going to acquit him and let him go. I imagine some of the other jurors saying, well, if that's the split you have in the jury pool, some jurors saying, I'm not sending him to prison, and the other half saying, well, I'm not letting him go, well, then insanity looks like a reasonable compromise verdict, because he doesn't go to prison, but at the same time, he's not simply being released into public again. He's going to be institutionalized and observed, treated by doctors in that institution until they determine that he's safe to release into society. And frankly, that'll probably happen pretty quick. I mean, by all appearances, the only people to whom Michael Barisone was ever dangerous was not people in general, but only these 2 people who set out to, and effectively did, destroy him emotionally, mentally, psychologically. So long as they're not in the picture, he ought not be a threat to anybody. So I expect he won't be institutionalized all that long. And frankly, a period of institutionalization, I mean, even if all you care about is the welfare of Michael Barisone, I don't think it's going to hurt him. I mean, I think this guy really is jacked up as a result of this experience. So this may very well be, in fact, even though it's not really a good fit with the theoretical black letter of the law as it might be taught in law school, might be the most reasonable justice we could actually expect from this case, given the totality of the circumstances and the conduct of the people. These were not just two, Kanarek and Goodwin were not just two innocent people going about their business, never did anything with malice towards Barisone, and he just woke up one day and shot him. That's not what happened here. They set out to destroy him in every way imaginable. And they finally broke him and got a bad result. And he should be held accountable for that bad result because it wasn't legally justified. But holding him accountable in this way, institutionalized until he's deemed by medical psychiatric professionals to be safe to return to society, probably right back to his horse farm, seems like pretty close to justice here to me. All right. So those are my initial thoughts on all this. I imagine a lot. Oh, by the way, the gun charge, completely acquitted on the gun charge. Now, there's a couple of ways to think about that. Again, we can't read the jury, so it's just speculative. But the charge was not merely unlawful possession of the gun, which would be a separate criminal charge under New Jersey law. My understanding of the charge was that it was possession for an unlawful purpose, which means you have to convict on the unlawful purpose, which, of course, would have been the case if they found any criminal liability for the use of force, either attempted murder or attempted manslaughter or any other lesser included unlawful use of force. That would have met the necessary foundation for possession for an unlawful purpose, good for 10 years all by itself. So here the jury might have decided, well, we didn't find him criminally liable for any unlawful purpose, so that means he can't be guilty of this gun charge, possession for an unlawful purpose. There was no unlawful purpose, legally speaking, so that has to go away. That could have been their conclusion. Although you'd think there would have been a lesser included, a mere possession charge, which is good for probably a year or two under New Jersey law all by itself. Or they just said, listen, again, they broke him and we're not going to hold him accountable for this gun possession. And by the way, this isn't a part of New Jersey that's not the most liberal. Well, maybe not the most. It's more rural than many parts of New Jersey. And maybe people in New Jersey do own guns. They don't carry guns a lot. Getting a concealed carry permit's hard. But there are hunters and there are people who own guns in their home lawfully. And, if some of them were on the jury, they may just have said, listen, we're going to nullify this one. We're just not going to hit them with the gun charge, given everything else. So that's a definite possibility. Again, we won't know. We can't know because we can't read the jurors' minds. And by the way, folks, I should tell you that whenever jurors are interviewed after the fact and explain how they got to a verdict, I never believe them. Most of those jurors are driven to do those media interviews because they're getting heat back in their local community, and they feel they need to explain away a verdict that's proven unpopular. And so they'll just make anything up to explain it away. It doesn't mean what they're saying doesn't carry any credibility with me at all in most circumstances, unless they're saying things that would be against their interest, and then you have to explain why they would be willing to do that if it wasn't the truth. But here I wouldn't really believe anything the jury said if there was any suggestion that they were simply trying to explain away a verdict that some people are criticizing them for, as I imagine the media will be doing. That's what the media does. All right, so let's take a look here in the chats. Oh, I wanted to pull up the actual reading of the verdict. I could have sworn I do have it here. Okay, so let me try to set this up just so we have kind of have it in the record. It all happens, I think, pretty quick. So I think when we open this up, I believe the judge is still standing. I have too many tabs open, folks. Again, I apologize for the messiness, even more messiness than the usual law self-defense production. I was kind of caught off guard here. But so this should be it. The judge is standing up. I believe the jury's coming in at this point. And I think this whole thing takes, if it takes 5 minutes, I would be surprised. So here we go with the reading of that verdict. See if we get this done before LNC shuts down my YouTube channel. I don't want to fast forward it because I think it'll just go too quick. think it happens really fast.
Be seated, everyone.
All right, here we go.
Mr. Foreman, please rise, please.
Oh, let me up the volume here.
Mr. Foreman, has the jury agreed upon a verdict in this case?
Yes,
Is that verdict unanimous?
it is.
With regard to count one, attempted murder of Lauren Kanarek, what is your verdict?
Not guilty by reason of insanity.
With regard to count two, attempted murder of Robert Goodwin, what is your verdict, sir?
Not guilty.
With regard to count two, the lesser included offense of aggravated assault upon Robert Goodwin, what is your verdict?
Not guilty.
On count three, possession of a weapon for an unlawful purpose to use against the person of Lauren Kanarek, what is your verdict?
Not guilty by reason of insanity.
And with regard to count four, possession of a weapon for an unlawful purpose, what is your verdict?
Not guilty.
Very good. You may be seated, Mr. Foreman. Thank you. All right, members of the jury, you have heard the verdict as reported by your foreperson. And I will now have a polling of each of you individually. And the verdict as read by your foreman is as follows. On count one, attempted murder, not guilty by reason of insanity.
Listen to this because they're mixed.
On count two, attempted murder, not guilty. On the lesser included offense,
No insanity
aggravated
there.
assault, not guilty.
No insanity there.
On count three, possession of a weapon for an unlawful purpose with regard to Lauren Kanarek, not guilty by reason of insanity. And finally, on count four, possession of a weapon for an unlawful purpose regarding Robert Goodwin, not guilty.
No insanity
If
there.
this is your verdict, as I go around, I'll call each juror's number. And if that's your verdict, simply say yes. If it's not your verdict, just indicate no. All right? All right, beginning,
Okay, folks, we're not going to go through the jury recitation. Be assured that all the jurors affirm that that was their vote. So it's interesting on the Lauren Kanarek related charges, the attempted murder of Lauren Kanarek and the possession and the lesser included assault and battery on Lauren Kanarek and the possession of the gun for unlawful purpose with respect to Lauren Kanarek. Those were all not guilty by reason of insanity. But for the charges related to Goodwin, the attempted murder, the aggravated assault, and the possession of the gun for unlawful purpose, those are just straight up not guilty. So those are absolute acquittals. So there's no institutionalization associated with those charges and those verdicts because it's a straight up not guilty. The only institutionalization would be with respect to the Lauren Kanarek, who was shot twice in the chest by Barisone. And therefore he faces that institutionalization for some indeterminate period of time. Now, every state deals with this insanity aftermath stuff a little differently, but I'm going to describe the norms. It's possible that New Jersey does it slightly differently, but typically the court would have some window of time, a 30-day period in which to hear motions, hear testimony from both sides about the nature of the institutionalization, where he should go for how long, under what conditions, and the court ultimately would issue some order to that effect. Whether it's 30 days or 45 days or whatever, I wouldn't know the details of that in New Jersey, but that's the general idea of what'll be moving forward here. In terms of the Kanareks and Goodwins, I'd like to think that they're off the property by now. I mean, all this happened a couple of years ago. If they're not, Barisone should never see them again, never be in proximity to them ever by his own choice and volition. And if they're not off the property yet, he should start formal eviction proceedings, which can take a long time and be a real pain, but ultimately would be successful. They're not privileged to live there forever under all circumstances, and not return to his own horse farm. He's got another one in Florida, not return to that New Jersey one until they are gone for good. That would be my advice. A lot of the cases I work on are aggravated assault cases involving a gun, involving normal people just like us, never been in trouble with the law a day in their lives, have a neighbor dispute. And frankly, the best, and sometimes I have to do those cases for the same person more than once because they get in a dispute with the same neighbor again. And my advice to them is always, move, because you guys are waving guns at each other. This is not going to end well. My real advice is to move if that's at all financially possible for you. And it's terrible that that's your only practical option, but sometimes that's the case. All right, folks. So I'm not sure. Maybe more thoughts will pop into my head as we go through, but I'll take a look and see if we have super chats that need to be addressed. Another case, before I do that, that's come up, or while I pull that up, I should say, is the case of this shooting in Grand Rapids. The shooting of Patrick Lyoya. I'm not sure how you pronounce his name. A suspect, a black male, who violently resisted lawful arrest, restraint, detention by a traffic officer who lawfully pulled him over, managed to get control of the officer's taser, refused to give up that control, and ultimately was shot once fatally by that officer. I did write up something for that hurriedly just before I went live with this, and I'll probably put that up on the Law Self-Defense website. May do a separate YouTube live broadcast. I have to break these things up because if YouTube finds one facet of one aspect of a live show they don't like, they demonetize the whole thing. But I probably will post up something later today on that shooting. Bottom line, it was, as far as I can tell from all the video available, and it's almost entirely on video, completely good shooting by the Grand Rapids police officer, not even close. And I will just note that there's a big difference between a defensive use of a taser for lawful purposes and an offensive use of a taser for unlawful purposes. One of those is non-deadly force. The other is deadly force. So this officer was not faced with merely a non-deadly force attack when he responded to that aggression with deadly defensive force. So that's a separate show, probably later today. I think I can find the time to do that. Let's see. I'll do this. Here we go. Let's see. CRJR, Hannah Payne. I already spoke to that. Dan, yes, score a 1 for pounding the table, I guess. So I feel obliged to say this because I spoke about the defense attorney, Edward Blinkus, throughout the trial. Thought he really was not doing a great job. Still believe that. Nothing's changed. The outcome doesn't change how I feel about the lawyer's performance. If you purely look at the outcome, I mean, the only way to look at this is a huge win for the defense. I mean, the defense could have gone a diminished capacity route, kind of a compromise verdict route, and the jury might have gone for that if the defense had argued at a closing. Look, I'm not willing to convict him of attempted murder, but we can go with manslaughter, attempted manslaughter. And that could have been many, many years in prison for Michael Barisone. But the defense didn't want that. They were all in. Either we're going to get acquittals, and insanity defense, that is an acquittal. I mean, you have the institutionalization thing, but there's no criminal liability. We're either going to get an acquittal or we're going to get sunk on attempted murder. That's it. And that's a gutsy move. It's risky because you're taking away that middle ground, but you're also avoiding the risk that the jury will compromise on a middle ground compromise verdict. And as it happened, it turned out here that worked out well for the defense. Now, the reason I don't let the outcome influence what I think of the juries is because these outcomes are, they're on a spectrum of odds, what's likely to happen. And there was nothing about this legal performance that made this more likely to happen. I just didn't think they did a very good job. But Blinkus won here. He won that acquittal for his clients. The insanity defense is still, as far as I'm concerned, from a criminal defense lawyer's perspective, still a complete win for his client. This institutionalization issue is nothing compared to what prison would have been. Probably it's to the benefit of his client to be institutionalized for some time. I just think it's a win all around. So credit for the win to Edward Blinkus. Would I hire him as my defense attorney? Nope. But he did the job for his client here with this outcome for sure. Yeah, and Alan, thank you for your super chat contribution. Alan writes, regardless of what you think of the legality of this, good, I'm glad he got off. And I'm sure a lot of people will feel that way. And there's nothing wrong with feeling that way. I mean, certainly I didn't like these people, Lauren Kanarek and Robert Goodwin. I thought they were vile, terrible, horrible people. But of course, I'm a lawyer. I'm not a social commentator or I don't know. I evaluate these things from a perspective of applying the facts as they are presented in court to the law that's applicable to the particular circumstances. And the law here, I mean, you're not allowed to shoot people because they're treating you poorly, no matter how poorly, absent an imminent threat of violence towards you. And that there was no such imminent threat, or at least no evidence of such an imminent threat here. So it couldn't be justified. I don't think the standard for insanity was really met, so I don't believe it could really be legally excused as insanity. But the way these people treated Michael Barisone and obviously broke him was clearly reprehensible. And frankly, folks, that's one of the reasons we have juries. I mean, this is a call. If this had been a bench trial, I don't think any judge would have made this call. The judge would have gone with a straightforward legal analysis. Maybe they would have mitigated sentencing to take into account the treatment of Barisone by Kanarek and Goodwin. So to the extent he had a range for manslaughter, for example, attempted manslaughter, he might have given the low end of the range, much as was done with Kim Potter, who could have been sentenced to as much as, by Judge Chu, to as much as 20 plus years in prison, like Derek Chauvin was sentenced, but instead was sentenced only to 14 months. Big difference between 22 years and 14 months. So I could have imagined a judge in a bench trial doing something like that, simply concluding not guilty by reason of insanity when it's pretty clear the evidence didn't actually support insanity. I don't think a bench trial would have done that. I don't think a judge would have done that as a finder of fact. But juries can do whatever they want, really, in terms of guilt or not guilt. And it's quite possible this jury exercised that privilege, that unwritten privilege here today. So, and it's hard to feel too bad about that. Again, these Kanarek and Goodwin were not just innocent people going about their day when they got shot by Michael Barisone. They drove him to the breaking point. And the chaos that resulted, it's hard not to attribute some or all of that to them, which I expect is what the jury did here. Walter Mellon writes, thank you, Walter, for your super chat contribution, writes, if she's a witch, you must acquit. Yeah, Belinkus. If Belinkus had gone for that, I would have sent them a free copy of the Law of Self-Defense for sure. By the way, speaking of which, we do have coming up this Saturday, which is only 2 days from today, I believe, one of our relatively rare Law of Self-Defense hard to convict webinars. Let me pull open that little image we have. These are our 100%, come on, little computer, work with me here. Our hard to convict webinars are 100% free. They don't cost a penny. They're just under 2 hours in length. And what they do is help show you the path to transform yourself from someone who's easy to convict, which used to be my own state, folks. When I was a young man, first got my concealed carry permit, was walking around in public with a concealed pistol on my person, presumably prepared to use deadly force to defend myself, my family. I had no idea where the legal boundaries for use of deadly force really were. And that made me incredibly easy to convict. Worse than that, than being ignorant, was I thought I knew where the legal boundaries were. I just didn't know I was wrong. I had been mistaught. I had read stuff in gun magazines or heard stuff from local self-defense CCW instructors or from retired cops, or all kinds of nonsense had filled my head. And I thought I knew where the legal boundaries are. And when I went to look at the actual law, I quickly discovered that no, I was mistaken. And if I had followed that teaching, that advice, I would have been extremely easy to convict if I brought that gun out for purposes of personal protection of my family. So I actually did the hard work of going to law libraries and looking at the actual law of self-defense for all 50 states, their statutes, court decisions, jury instructions, and made myself hard to convict. Because if you know where the actual legal boundaries are, you are, and you stay within them, you are incredibly hard to convict. The state has to disprove your claim of self-defense beyond a reasonable doubt. That's a pretty strong position to be in if you are, in fact, within those legal boundaries. Well, I want to share that journey with all of you, that transformation with all of you from being easy to convict to being hard to convict. And that's what we do in the course of these webinars. We we bust a number of common self-defense law myths. We tell you what the truth is in terms of the actual law of self-defense in those circumstances, and we show you a path to getting from being easy to convict to being hard to convict. We're doing that this Saturday at 2 p.m. Eastern Time, streamed over Zoom. It's live, being taught by me, just much like you're watching me now over the internet, for all you boomers out there. And it's 100% free, but there are a limit of 100 seats for each one. I think we have just a handful of seats left for Saturday. So if you're interested at all in that transformation from being easy to convict to being hard to convict, I would urge you to sign up for Saturday's class. If that's filled up since I started talking, then that date will have disappeared off the registration page. But there will be later dates in the month of April and May that you should still have seats available to sign up for. But you can learn more about this webinar and grab your seat. Please don't sign up for more than one day. I ask as a favor, because there are limited seats for each. And all the webinars are basically the same. They're all live, so there's a little bit of variance, but the underlying message is all the same. You can sign up for your 100% free seat at that Hard to Convict webinar. And again, there's one this Saturday at lawofselfdefense.com/hard to convict, lawofselfdefense.com/hard to convict. And hopefully I'll see a bunch of you there on Saturday. I'll be there. Shirt and tie, folks. Shirt and tie. That is not a no tie event. Let me take another quick look here at the super chats. If I can try to do my show in the Ricada way. Looks like I still got them all answered. So I was, I'll confess, it was interesting to see how long the jury was taking. That certainly suggested at least some kind of compromise verdict for sure, as opposed to a straightforward guilty on a charge or straightforward acquittal. But apparently that was the kind of discussion and debate that was happening within the jury room there. So this, let's see, what else did I have? I have a bunch of stuff that I've been meaning to get to with everyone here. These little cases come across my desk that none of them are really worth, none of them are worth covering by themselves because they're not that long, but they can be worth covering collectively. And one of those is, this will probably get me demonetized, but there was a road rage video that came up shortly, a short time ago. Let me see if I can pull that video up to share with all of you for educational and informational purposes only, of course. All right, it looks like I can do that. So this shooting does not appear to have taken place in America. Most of these videos like this come from various Central American countries. But for our purposes, let's pretend that it happened in America. And what we'll see here is an apparent road rage incident. We'll see two dark colored cars, one of which pulls in front of the other in the middle of this camera frame. The car that pulled ahead, a gentleman gets out with a baseball bat, walks over to the driver's side door of the other vehicle with the bat lifted, clearly in a threatening manner. It may even take a swing with the bat. I forget. We'll see that when we watch the video. Unfortunately for the guy with the bat, he brought a bat to a gunfight, and he's met with a fusillade of pistol fire. Pistols are generally pretty ineffective stoppers unless they hit something really vital. And this guy with the bat manages to turn away, walk a short distance before he falls to the street. Even when he hits the street, he's still moving. But that stops shortly after the fusillade of fire continues. So let's take a quick look at this video and I'll show you what I mean. There's the two cars. Guy comes out with the bat. There he is. Hey, I'm going to show you. I got the bat. Oh, wait. All right. So there's good news and there's bad news here. By the way, the guy on the ground's still moving at this point. But you know, a lot of people get shot with handguns and they run or flee or they're moving for a while, but they're actually mortally wounded. It just takes a minute or so for the body to catch up, and certainly he appears to stop moving shortly later. I guess we don't really need to see that, but there's good parts and bad parts to this video. So lessons to be learned. One is first, don't do this. I mean, unless someone's kidnapping your child, you do not want to be forcing another driver to stop in the road. Nothing good is going to come from that. Get out of your car with a bat. Well, you've just made yourself a deadly force threat to that person. And unless they were already presenting as an imminent deadly force threat to you, which does not seem to be the case since you had to pull them over, coming out with the bat is presenting as an unlawful deadly force threat against which they would be legally privileged to use deadly defensive force, which is what happens here initially, especially after the actual bat swing. Now it's no longer an inference that there may be a deadly force threat. You swing a bat at somebody, that's a deadly force threat. That bat swung is readily capable of causing death or serious bodily injury. That's a deadly force threat, my friend. So this, the driver of the other car who responds with gunfire, apparently blocked, unable to safely flee, been pulled over by this guy. Retreat's not an option. Subject to a bat attack right there. He decides to present a pistol and use deadly defensive force. Looks to me like the guy with the bat sees the gun at this point. He's back wheeling pretty quick. Realizes he brought a bat to a gunfight. Never a good idea. And we have a number of shots fired right about here. Bang, 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 bang. And all these shots may be perfectly lawful. Probably are reasonably lawful. He's using deadly defensive force to stop a deadly force threat. So far, so good. Of course, the more the guy with the bat turns and is in apparent flight, and you know, he's running out into the street. He's not running for cover to use his bat from a position of cover, right? That's not what's happening here. He's just trying to flee. He's no longer a deadly force threat at this point. Still shooting. I mean, it's just within, you know, the decision to shoot occurs a tenth, two tenths of a second prior to the shot actually being fired. So, you know, you get away with one or two of these, maybe. Striking the guy in the back, striking the guy as he's fleeing, as he's falling. But once a reasonable person would have realized they're no longer facing an imminent force threat, like, say, at this point, then the window of eminence has closed. That person who had the bat is no longer presenting as an imminent deadly force threat, and your privilege to use deadly defensive force upon them is over under American law. I have no idea what they do in Central American countries. Maybe they go by the, he earned a killing doctrine. But under American law, you're only privileged to use deadly defensive force so long as there remains a unlawful, imminent, deadly force threat presented by the person you're using force against. That's not the case here anymore. Yet this guy, the driver of the pulled over vehicle, comes forward, raises his gun, and there's a pop, pop, pop. Looks to me like he's shooting for the back of the other guy's head, which even with a low-powered handgun tends to be effective stopping. Of course, you don't really need stopping here anymore, and that's the problem. So these shots would not be legally excusable under any circumstances. These are, now, you might be able to argue for mitigation. You might argue heat of the moment, passion, adequate provocation, that this final shot should be deemed manslaughter, not murder, because of the provocation of the guy with the bat. I think that would be a reasonable argument. It's happening in a very short period of time. It's not like the guy in the blue shirt is seeing the guy in the red shirt the next day and shooting him in the back of the head. This is all part of the same event. I believe the window of eminence is closed here, so it can't be self-defense, but it might be an imperfect self-defense or a manslaughter kind of compromise verdict in this kind of shooting. So that was one I had in an open tab waiting to share with all of you. Probably my demonetization of the day video. We'll have to see. Oh, and I just saw penis comments in the chat. Come on, folks. Come on. Start your own YouTube channel if you want to talk about penises in the chat. That's not appropriate. for a channel that shows people shooting each other dead in the street. Sorry about that. All right. Well, YouTube is, of course, being slow. And all right, still no more super chats. Let's see if I had something else in the queue to share. I'm sure I did. That was Road Rage. Oh, here's one. Yes. Firearms instructor criminally charged for a use of force. Yeah, folks, I often caution you cannot assume that somebody knows actual use of force law just because of their job title, whether they're a cop or a lawyer or a firearms instructor, for sure. Let me see if I can pull this up. So here we have a guy. That didn't work. Let me see. This does not work with Word it doesn't work with Word documents. All right. I'm sure I have this in some other format. Let me see if I save the URL. I can go right to the news reports. I accept cookies. And apparently ads. Let me see if I can do something about these ads. If I turn on the ads, sometimes the news story won't show anymore. All right, so far so good. So let me go back here and let me pull this up to share. This is out of Las Vegas. Las Vegas, where I will, oh, no, they hit me with the ad blocker warning. Okay, sorry about that, folks. Looks like we will have to live with some ads. Bastards. Oh, the ads are so terrible. They pop up constantly. All right, let's see what we can make work here. No, I don't want to subscribe to your news channel. All right, Las Vegas Review and Journal. Firearms instructor charged with murder after shooting suspected car thief. All right, so first of all, can you shoot a suspected car thief? Can you shoot someone over a pure property crime with no threat to persons in play? Well, if there is a threat to persons in play, it's not a property crime. Then it's a threat to persons crime. And then the normal rules for self-defense or defense of others apply. But in the absence of a threat to persons, it's simply a property offense, especially if we're talking personal property, and an unoccupied car is personal property. Now, there is one state, Texas, that does have a statutory provision for the use of deadly force in defense of even mere personal property. That's Texas Penal Code 9.42. If you'd like to read that statute, you can find it at lawofselfdefense.com/942. When you do read it, you'll see there's a lot of hoops you have to jump through there, a lot of subjective judgment calls that will be made by other people. And if you miss any of the hoops or fail the subjective judgment calls made by other people at a later time in complete safety, then you don't qualify for that statutory provision, and your use of deadly force in defense of property was simply unlawful. And if you killed someone in that event, it's just murder. That's not a great place to be. So even in Texas, I would discourage you from using deadly force in defense of property. In the other 49 states, there is no privilege to use deadly force in defense of mere personal property in the absence of a threat to persons, period. And that includes Nevada, where Las Vegas, well, this Las Vegas at least, the big Las Vegas, is located. So you can't shoot someone because they're trying to steal your car in the absence of a threat to persons. Now, this will be complicated a little bit because this firearms instructor was apparently also a gun owner. Let's see, his name reported here is Carlos Viana, 34. I believe he was also a gun owner, so an FFL, possessor of a federal firearms license. Had a warehouse full of guns, drove a Mercedes, nice to drive a Mercedes. and was loading guns into his Mercedes or loading them out of the Mercedes. And anyway, at any point, guns were somehow being moved between the Mercedes and the warehouse. There were guns in the Mercedes. And while the car is out there, the Mercedes is out there, some dude jumps in to steal the car. Car's unoccupied. The owner's not in it. But he sees the car being meddled with. He sees the car being stolen. So he starts shooting at the car. He says the car started driving in his direction, which is why he shot at it. And that might be a reasonable basis for the use of deadly defensive force, because then we're not talking about a pure property offense anymore. There we have a threat to persons, an imminent threat to persons. The car is being driven at you. The car is being used as a weapon. Now, frankly, I'm not sure firing a handgun at the windshield of the car is a great way to stop it from being used against you as a weapon. But maybe if you feel that's the only option available to you, you work with what you have. So if anyone had believed that that's actually what happened here, that the car thief was driving the car at the owner, well, then it's not a defense of property situation. It's a defense of self situation. And the use of deadly defensive force may have been warranted if those 5 elements of self-defense. Hopefully by now you're all familiar with the 5 elements of self-defense. If you're not, you can get our 5 elements cheat sheet at lawofselfdefense.com/elements. It's 100% free, just a PDF download. If you don't know those 5 elements, you can't possibly understand use of force law. But if the car is being driven at the owner, well, then the owner's defending himself. He's not defending his car. Unfortunately for the owner, there was surveillance video that captured this event, and the car was not apparently being driven at the owner at all. The owner was not in imminent threat from the vehicle. So the owner wasn't really shooting at to defend himself. He was shooting at the car as it was being driven away by the car thief. By the way, he may not have known much about use of force law or about not lying to the police, especially when the lie is going to be captured on video. But apparently it was a reasonably good shot because he fired 2 shots at the car thief, and the car thief would later die at an area hospital. Here we see in his arrest warrant, the police looked at surveillance video that showed Viana, the quote-unquote defender, was out of the vehicle's path when he fired at Marks. The police said in the warrant, Viana was on the driver's side of the vehicle at the time of the shooting and was out of the vehicle's path as it moved forward. So that's the issue. If he was in imminent physical danger from the car as it was being operated by the car thief, well, then that's a reasonable self-defense argument to have shot the car thief. But if he wasn't, cars don't move sideways, if he was beside the car, not in its immediate path, then he was just shooting to keep the car from being stolen. Now, apparently there were firearms in the vehicle. Would that justify shooting at the car thief, that there were guns in the vehicle? No, because unless the guns are being wielded in a threatening way, they are also merely personal property. Now, we all hate to think about a car thief driving away with a carload of guns. We know where those guns are going to end up. Maybe you could make a necessity argument there, desperately, that, hey, sure, I shouldn't have fired those shots at that car thief, but I committed that offense to prevent a greater offense, or a greater harm. The necessity defense is sometimes called the doctrine of lesser harms or the doctrine of lesser evil. And the idea is that you commit some relatively small harm to prevent a much greater harm. An example would be breaking the glass of window of a car to retrieve a baby left in a hot sealed car on a hot summer day. So you're breaking the window. That's destruction of somebody else's property. That's normally unlawful, but you're doing it for a greater good to save the life of the baby. So that is a legal defense that exists, the necessity defense, or the doctrine of lesser evils, or doctrine of lesser harms. So you might argue, well, I shot at the car thief, which normally I guess should not be allowed. I get it. We don't have deadly force in defense of property here in Nevada. But I did that harm to prevent a much greater harm, which is that a trunk load of guns would end up in the hands of criminals, which would be a reasonable expectation for where those guns would end up, for sure. But the necessity defense doesn't really work when what you did was take a human life, because the courts are balancing the harm you committed against the harm you avoided. And the harm you committed in this instance was you actually killed somebody. The harm you avoided was a theoretical threat of deadly force harm to others. Maybe someone will die from the stolen guns. I mean, it doesn't seem a low probability, but it's certainly not a certainty. And what you did was a certainty. You killed that guy. So that's not going to look like a lesser harm compared to the theft of the guns. And if the guns are just in the trunk and not actually being wielded as an imminent threat by the thief, then they don't represent an imminent threat to you. So there is no justification defense there based on the guns. And I know I can see in the comments lots of people, thieves deserve to die. I get that from a philosophical perspective. We all work hard for our stuff. We didn't get it for free. We gave up days, weeks, months, years of our lives to generate the wealth that was required to possess that property. So when people are taking the property, it's not really just an inanimate object. It's everything that went into acquiring that inanimate object. I get it. And perhaps that's the political philosophy that underlines Texas having a provision for the use of deadly force in defense of property. And maybe many of us would like to live in a world in which the use of deadly force in defense of mere property was lawful, as it is under limited conditions in Texas. But unless you live in Texas, you don't live in that world. If you live in Nevada, you don't live in that world. Nevada law, 48 other states, every other state except for Texas, zero privilege to use deadly force in defense of mere personal property, period. So you can say that the car thief deserved to die. Maybe he did in some kind of moral sense. But that shooter here, owner of the car, FFL, firearms instructor, pretty good shot, apparently, was not legally privileged to use deadly defensive force in the absence of a threat to innocent persons. And that's really all there is to that. So he's in a bind. Let's see. What else do I have to share with all of you? Probably a bunch of stuff. Let's see. Oh, this is another video. I'm not sure of the best way to share this. I might actually need to export that. Let's see. Yeah, so this is what you get, folks. You see it all live right here in real time. See how long this takes to get up and running. Here's a different shooting event. A car thief event. Let me see if I can pull up this news story. Well, this is actually a YouTube video. So here's another car theft attempt. We just had one, right, where it was, I pretty clearly stated that this was not a lawful shooting. The FFL down in Las Vegas. And here's another case. I believe this is Texas, outside of Houston. So another car theft case, but I think if I recall correctly, it has quite a difference from the previous example in a very important way. Except I have various parts of my computer locking up. Well, this seems unnecessary. I see, well, I'm trying to figure this out. I see a super chat here from C. Goody. How would you feel about nonviolent criminals or felons still having Second Amendment protection / rights? Folks, I would restore Second Amendment rights to violent felons, to everybody. My position is either you are too dangerous to have out in society, in which case you should be kept in prison for demonstrable reasons. You were convicted of some violent felony, and you ought not be released from prison unless we have reason to believe that you're prepared to act consistent with civil culture, again, civil society. In which case, you should simply get your Second Amendment rights back so you can be a normal, productive member of society. So either we believe you're prepared to do that, or we don't. And if we don't, we ought not let you out, because If we think you're still too dangerous to have a gun, what happens the instant you let that violent felon out of prison? Or even an anti-violent felon? If they want the gun, they have a gun. Gun laws don't keep guns out of the hands of criminals, not in America, not in a country with more guns in circulation than people. No criminal doesn't have a gun because he doesn't know how to get one if he wants one. When I worked as a diesel mechanic in Harlem, New York, we routinely had cars roll into the yard, pop their trunks, and we could buy any gun we wanted. No background check, nothing. That's where bad guys buy guns, out of the trunks of cars. They don't go to an FFL. They don't do a background check. Or if they get the gun from an FFL, it's not them doing it. They start dating some pretty little thing who goes into the FFL and buys the gun in her own name, but for them. And so they completely bypass all the regulatory systems for gun purchasing. So all these gun laws do nothing to constrain actual bad actors. So my view on Second Amendment rights is if you're a felon, you go to prison, you serve your time, you pay your debt to society. Either you're too dangerous to let out, or we decide you're safe enough to let out. And if we're going to decide you're safe enough to let out, there's no way for us to actually keep a gun out of your hands anyway. So we may as well not pretend. If we believe you're reformed and you're prepared to be a productive member of society, I want every productive member of society who wants to be armed, be able to protect themselves and their family from criminal predation, to have that privilege. And if they did something bad in the past but have paid their debt, well, what are we supposed to be doing with these people? Treating them like half citizens? So no, I'm a Second Amendment absolutist when it comes to that kind of thing. All right, folks, let me see if I can share this video. Hold on a second. I do have that second video I was trying to, yeah. Okay. I'm trying to export this so I can use it again in just a moment. Oh, maybe it is available already. All right, so let me go to this property crime event if I can pull this up. Do that first before I share that other video with you. Let's see. All right, so again, this is a TV news report. Everything that the media says is they're just a bunch of lying liars, lying all the time. So, we can only half believe anything they say. But for illustrative purposes, I thought this might be entertaining. So let's take a look at what they have to say here. Whoops. Here we go. Okay, let me try it again. Yeah, well, they ought to be pretty concerning. That's what's leading to the crime spike in America. So what might be different about this case as opposed to the previous one, the Las Vegas one? So this one out of Houston, the gun owner, now we don't know where the guns were in the car, but I suspect they weren't locked in the trunk. They might have just been, say, in the passenger seat of the car. The guy's coming back from a gun range. Pretty silly to stop at a gas station and gas up and go inside the building and leave a bag of guns on the seat of your car, but maybe that's what happened here. If they're on the seat of the car, maybe it's a more reasonable expectation that the multiple people inside your car have accessed that bag and have weapons. Frankly, it's not the position I would want to be in. If I saw two guys rolling off with my car in this circumstance, they're just rolling off with the car. I'm not getting into a gunfight over that car, especially not if I believe they've accessed the weapons inside the car, which really presumably should be unloaded unless they load them up. They've already loaded them up. But if they're stealing my car and I have reason to believe they have loaded weapons in hand, what am I doing? I'm not getting into a gunfight there over that. That is nonsense. Oh, there wasn't sound on the video, sorry, but it doesn't really matter, to tell you the truth. Let's see if there's any other super chats that have come in since the last time I checked. No sound. Well, the video, let me see. I don't know. It was playing for me. Let's see if I can. No sound. Okay. That sounded great. It's a short enough video. I'll try it again here. See if I did something wrong. This should have sound now.
The scene cleared just about an hour ago. The shooting and break-in happening just over at Pump 1, where you can see that glass on the ground, that coming from the vehicle. That's where investigators say two men were trying to break into a car. The shooter is the owner of that car and a customer at the Shell gas station. Sheriff Ed Gonzalez says he was actually coming out of the store when he realized something was wrong.
As he approached, he noticed the car backing up in an effort to evade and flee the location. And so being in fear because inside his car was a bag with other weapons, he was afraid they had possibly obtained them. So he opened fire on the vehicle.
Sheriff Gonzalez says both suspects were hit but managed to get away. Both have since been taken into custody and are being treated at the hospital for their injuries, but are expected to survive. The shooter, according to the sheriff, was coming from a gun range, which is why he had a bag of weapons in his car. He could be seen earlier with brown bags over his hands for evidence purpose. The sheriff acknowledging that this sort of crime is happening way too often.
People are very frustrated. There's frustration.
Okay. By the way, folks, the fact that he had bags over his hands, that's not a good sign for this shooter. They're doing that to preserve gunshot residue on his hands. Presumably, he's already conceded that he's the one who fired the shots. So you don't need the proof to corroborate that he fired the shots unless you were looking at prosecution. Otherwise, you would just take him at his word that it was lawful self-defense, right? I mean, if you were taking him at his word that he was justified, you don't need to preserve the gunshot residue on his hands. Also, it's important to keep in mind that there's a lot of, subjective judgment call here in these kinds of cases. I don't know if that license plate was for this guy's car. It sounded like the car thieves got away and got caught later. Did they get away in the car? I'm not sure. But if it was this car, it had a, U.S. Army theme license plate. So maybe he's a veteran. That would lean in his favor with most law enforcement. He was at a gun range. Maybe he's got a concealed carry permit, so he's done a background check. He's got guns that he bought. If he bought them lawfully, he's probably done a background check. So that would lean in favor with law enforcement. But don't presume that because law enforcement is leaning favorably towards someone, that that's the way they have to lean. They can lean the other way. They can apply their judgment, their discretion in the opposite direction and make your life a hell. That's why it's always important to make sure that, legally speaking, you're prepared not just for what the authorities might do if they happen to be feeling favorably disposed, but also to what they could do if they're not feeling favorably disposed. The next video I wanted to share with you is related to that Grand Rapids shooting event where the suspect Patrick Leola had seized control of the arresting officer's taser, refused to give up control of the taser, and the officer ended up shooting him. Looks like a lawful shoot to me from every perspective. One of the issues there was it's possible that the officer had fired the taser at least once, fired the darts from the taser with no effect, which happens very often. It's hard to tell from the actual video. It sounds like it may have been fired twice, which is the total capacity of tasers. I mean, some tasers only fire once, some fire twice, but twice is the most. Then you're out of darts. So there is no more dart projection happening. You can still use the taser in press mode, contact mode. So press the muzzle of the taser against the other party with disabling effect, not as disabling as the darts, but nevertheless disabling effect to some degree, extremely painful. So even if the taser had been fired shot, that doesn't mean it's an inert object now in the hands of the suspect. The suspect could still drive stun the officer, disabling the officer, seizing the officer's service pistol, even if the taser had been discharged twice. And the fact that the taser was discharged once or twice and didn't work is not at all uncommon, folks. I'm glad tasers are a thing that exists in the world. They give police officers an option. Normally, the best application of a taser for officers is where you have multiple officers. So one is giving the taser a shot. If they don't have to shoot that suspect, that's better for everybody. If they can disable him with the taser, great. But next to that officer is usually a cop with a drawn pistol. So if the taser poops the bed, Amber Heard style, the second officer is prepared to use deadly defensive force should that be necessary. That's the optimal operation there. A taser used by an officer alone without that kind of deadly force backup, as was the case here in Grand Rapids, much more sketchy. Similarly, for a civilian who has a taser for defensive purposes, they very often don't work, folks. And for skilled suspects who've been around the block a few times, there are specific techniques, which I won't detail here, but specific techniques they can use to defeat the taser dart approach without much difficulty, to tell you the truth. Those techniques don't work every time, but they work a lot of the time. And tasers don't work a lot of the time, even when the person they're being used on doesn't know any defensive techniques against them. That said, when they work, they often really, really work well. And the person who is shot with the taser simply drops like a stone. So what do we got here? I'm going to pull this up. I didn't really edit this video very well, but I think I have it more or less at the beginning point here. Let's see, share the video. So what we have here is a woman in a Walmart. Looks like she's a Karen mask, a mask Karen. In a Walmart, she's holding a knife in her hand. She's pissed about something. I have no idea what she's pissed about. The cop here has a taser. He's deploying right now for the first time. And he's apparently been engaged with this woman for some time, has lost patience at this point. Presumably, he's been giving her commands for quite some time to drop the knife. She's refused up to this point to drop the knife. So now he's going to the taser, and he'll rather perfunctorily say again, drop the knife, drop the knife, drop the knife. But he's not waiting very long before he actually activates the taser. And this is the way a taser works in those rare occasions when it works effectively. And when it does, it is an amazing product, which is how it gets sold to police departments, right? So let me see. Let me make sure the volume is up on this. It was not. All right. Now it should be up. Very short video. Let's see. See if I can wind it back to the kind of the beginning. Okay, here we go. All right. So there you see a little red circle there on the screen. Perhaps that's the knife in her hand. It's been highlighted, and somebody did a little post-production here. This is obviously a Walmart. One of the best places I ever taught my live in-person law self-defense classes was in a a gun store. I believe the name of the place was the Gun Store, literally. If I recall, it was in California, somewhere in the Sacramento area. But I believe the name was actually simply the Gun Store. And it was in the parking lot of a Walmart. So I thought, this is perfect. You get your self-defense tactical and legal training here in the gun store. And the moment you step outside the door, you're in a Walmart parking lot where you can put all this into immediate practice. So there we go. So here's Karen, the mask-wearing, knife-wielding Walmart lunatic, refuses to comply with police officers to divest herself of the knife, even though she's obviously not under imminent threat from anybody. So she can't possibly have a justification for wielding the knife in this way, contrary to the police orders. So here we go.
Drop the knife now. Drop the knife now. Drop the knife now.
I know I should feel guilty for laughing out loud, but oh my gosh, when she hits those benches and you hear that big bang. So that's the way a taser is supposed to look. Obviously, her musculature is completely locked up. She's got no control over herself. And she just topples to the ground like a statue that's been knocked over. And the cop keeps his finger on, on that trigger. I mean, he rides her all the way to the ground. So when they work great. Unfortunately, very often they don't work, which we should keep in mind when cops are making their use of force decisions, especially in fast-moving, deadly force type of threat environments. The taser is not a magic weapon. It doesn't always do this. I would suggest you're lucky if it does this half the time. So there you go. Something to keep in mind. And one of the reasons I don't recommend tasers for civilian self-defense, not that I would make it illegal. I mean, as far as I'm concerned, you should be able to carry really whatever defensive weapon you care to. It's all fine with me. I just don't think they're reliable enough that you'd want to stake your life on one. My preference is OC, which is also not perfect. So there you go. You make your choices and you take your chances. All right. Let's see if there was anything other pressing I wanted. Oh, here was one. Here was one. This is a common bad idea. Also, a YouTube video. See if I'm going to get struck by using all these YouTube videos. These bastards. This is all for fair use purposes, folks, for criticism, commentary, educational purposes. Of course. I shouldn't even have to say that, should I? Okay. So let's go to this case. I'll pull this up on the screen here. Turn off Taser Karen. And I will pull up this new video. This involves a dude who made the probably imprudent decision to fire warning shots. And now he's on his way to trial. By the way, I love the little graphic behind the reporter. Self-defense law under fire. No, there's nothing about the self-defense law that's under fire. This particular defendant's judgment may have been poor, and he may be subject to legal liability because of poor judgment, but there was nothing wrong with the law. I mean, obviously, if he's being prosecuted, it's because the authorities believe he broke the law, not because he was acting consistent with the law. I did see a question here in the super chats about from Content of Character. Thank you for your super chat contribution. Has Kim Potter filed an appeal yet? I haven't heard that she's filing an appeal. It's not something I keep an active eye out for. If it happens to, be reported in the media, it'll be brought to my attention, and I'll be sure to cover it then. But I don't think she's going to file an appeal. It's a costly, risky effort that could put her in a far worse position than she is now, and I'm not sure what the upside would be. Yes, she's a convicted felon now, but she's already out of her police job. I mean, she was finishing her career at the time this all happened. So she was never intending to be a cop again. I'm not sure she cares about owning a gun in terms of the felony conviction. I guess it's bad for her reputation. Did it lose her pension? I don't know about that. But remember, if you appeal, the appeal can take years, many years, and she's only sentenced to 14 months. So it's not like, if she was sentenced to 10 years, I definitely would have appealed because there was a miscarriage of justice in her case. The court allowed the jury to be lied to by the state prosecutors about what's required for recklessness. And she was convicted of reckless manslaughter. So that was an injustice. And if she had been sentenced to 10 to 20 years, which could have happened, I definitely would have appealed. But she was only sentenced to 14 months. So by the time any appeal would come before the appellate courts, she's already served her sentence. So you're not saving her from the sentence. You're only saving her from the felony conviction on her record. And even if you do that, even if the appellate courts say there was an error, and there clearly was, and they remand for a new trial, she's not found not guilty. It's just a new trial. And are we sure the new trial would go better? Or would she be politically convicted again? Would the prosecutors be allowed to lie again? And if they are allowed to lie again, would a different judge on retrial give her the 10 to 20 years? Credit, of course, for the 14 months time served. I mean, that's not a risk I would want to run. If I was looking at up to 20 and I got 14 months, would I appeal that? I don't know. So I have my doubts. Let's see. Shut Up, I Can Cook says, I sent a $20 super chat with a question. Did you miss it? I did miss it. So thank you for reminding me. Apologies, it took you a second super chat to bring that to my attention. Shut Up, I Can Cook says, the chat seems to want to shoot any and everybody. Well, that's how people talk on the internet, right? Somehow I doubt any of these people have actually ever shot anybody in their entire lives. So are they really going to shoot somebody? Maybe. Hey, somebody has to pay for my costly German motorcycle collection. It doesn't pay for itself. So the chat seems to want to shoot any and everybody. They're failing to hear your wisdom. Not only are they taking a life, but their bravado to shoot and kill will forever change all lives involved in a bad way. Yeah, you ought not be shooting people. You don't need to shoot, folks. And by need to shoot, I mean in preservation of innocent life, period. Are there rare circumstances where the law may allow for the use of deadly defensive force beyond that, particularly in Texas, as we talked about, for defense of mere personal property? That can happen. It's on the edge. You're taking a high risk, and the cost of losing is the rest of your life in prison. But even if it were lawful, is it really worth it? Is it really worth it? Because remember, there's never a 0% chance of getting convicted. You could do everything right. You can act in lawful defense of innocent life, of yourself, of your family, and still run into a rogue prosecutor and a crazy jury and end up convicted and sentenced to the rest of your life in prison. So I always encourage people to think to yourself, if that's the outcome, if the outcome is the rest of your life in prison, under what circumstances would that be worth it? Because there are circumstances in which life in prison is worth it, right? If your family were going to be maimed or kidnapped or raped or killed, yeah, I'd rather be in prison than have any of those things happen. But once I get past that pretty short list, am I willing to go to prison to keep my car from being stolen? I'm not. Are you? Are you willing to go to prison for the rest of your life because you came to the defense of a stranger who then told the responding officers that, oh, her husband wasn't the problem, the guy who was beating her in the face, who you rescued her from? You were the problem when this lunatic showed up with a gun. You willing to go to prison for the rest of your life for her? You have any control over how she's going to testify about what happened? You don't. You're putting your life in the hands of what? Somebody who later will turn out as a meth head? So I think you need to think about these things carefully, folks. And all this bravado on the internet counts for exactly what you paid to post it on the internet. If anything, it can hurt you. If someone were to discover it was you posting that stuff. And if you imagine anything on the internet is actually secret or private or deleted or unknown, you're living in a pipe dream. Pipe dream. If you've killed someone and the authorities want everything you've ever done on the internet, man, I wouldn't tell the most expert IT person with the best VPN in the world that it's impossible for the state to get those records, because it's not. It's not. If they want them bad enough, they'll get them. Let's see. Yeah, a madman, 20 pounds. So I guess you're in the UK or some variant of the UK. I always get those political delineations a little vague for me, unfortunately. The UK, Great Britain, they're I know they mean different things, technically speaking. I can never quite keep it right. I know they use pounds. I've been to England using pounds before the euro and then again after the euro. But why risk pulling a taser after Potter? That cop goes to jail. If she dies, surely better to point a gun. Yeah, I mean, what happened to Potter is certainly, to my mind, just having a taser on the belt now. If what the prosecution argued in the case was that merely putting on that duty belt with a gun and the taser on it was sufficient grounds for a finding of criminal recklessness, that's insane. That means every cop who puts on that duty belt with a gun and a taser every time they put on their belt has met the foundational conditions for a reckless homicide if they happen to pull the wrong item. That's not how recklessness law works, folks, not how it's supposed to work. You're supposed to be found guilty of reckless killing only if you knew consciously you were creating a risk of death in the moment, an unjustified risk of death, and you ignored that risk and the person died. Drunk driving is the example. You get juiced up, you get behind the wheel of a car, you know what you're doing. You know you're creating that risk of causing a vehicular homicide, and you did it anyway. And then you kill somebody. That's vehicular manslaughter, which is a form of reckless manslaughter. But if you don't know you're creating a risk, then it can't be recklessness. If you think you're carrying a loaf of bread and you deliver it to a home and it later turns out it's a bomb, but you had no idea, you were not creating that risk knowingly. And there's no evidence Potter knew she had a gun in her hand ever. Not even the state argued that. The state argued they didn't have to prove she knew she had a gun in her hand, which is ridiculous. Because if she didn't know she was creating the risk in the moment, and she didn't, then it wasn't reckless, strictly as a matter of law. So the state's argument in the Potter case was essentially that, listen, she knew she had a taser and a gun on her belt, and therefore it's up to her not to pick the wrong one. That's a negligence argument, folks, which is not criminal. That's civil liability. That's not a recklessness argument. Recklessness requires she knew she was creating a risk of death, unjustified risk of death in the moment, and there was never any evidence that she knew that. But if the state's argument is that merely having the duty belt with both items, gun and taser on the belt, creates the foundation for reckless homicide, yeah, as a cop, I don't know why any cop would carry both, for sure. Contrarian 420, thank you for your contribution. Writes, agree or disagree, Belenkis is the most incompetent victor of 2022. He certainly comes across to me as a guy who kind of blindly blundered himself into a tremendous victory for his client. Sometimes that happens, right? Even a blind squirrel, blah, blah, blah. Maybe I'm wrong. I mean, maybe he operates on, 10-dimension chess levels that I just can't possibly see. What I saw was a guy who was just not a very good attorney in that courtroom. Sorry, that was my call at the time. It's still my call now. But he was lucky enough that the people who his client had shot at were so vile and despicable and so hate-filled with monstrous intentions towards his client that they broke him as a man, as a human being, that they were simply unwilling to convict the client. So to the degree he sold that narrative to the jury, I got to credit him for that. That's his win. That's appears to me ultimately what the jury ended up doing. I think it's a high risk, low rate of win strategy, but at least in this case, it worked for him. So I'm certainly not going to take his victory away from him. This was a not guilty by reason of insanity was almost certainly the best outcome Michael Barisone could ever have hoped for, and he got it. So credit where it's due. Again, I would not hire Edward Belinkus to be my defense attorney. Not in a million years. But that doesn't take away the win he got for his client here. Shut Up, I Can Cook, another super chat contribution. Thank you. Writes, recently, Branca, a civilian was shot and killed trying to intervene in a domestic violence situation. I watch Active Self-Protection. I saw it there. I say call the cops, but when seconds count, what say you? So for those who may not know, can I pop this up? Oh, look at that. I'd forgotten I could do that. So for those who don't know, Active Self-Protection is a YouTube channel run by John Correa. It's not spelled like the country Korea. It's more complicated than that. But I'm sure if you Google Active Self-Protection or search for it on YouTube, it'll jump right up. It's a channel with millions and millions of views, I think. And when what John does is he takes these videos of personal violence events and does a kind of an analysis, mostly tactical, some legal, on those events. Now, I will say John is a graduate of the Law Self-Defense Instructor Program. Proud to say that. And to be a graduate, certified graduate, you have to pass a final exam. I think the passing grade is 90%, something along that order. And he passed that and got certified in our Law Self-Defense Instructor Program. So when he does the legal stuff, he does a good job. I don't always agree with his conclusions, but then I'm a lawyer and we tend to be argumentative. But by and large, he's very, very sound on the legal stuff. The tactical stuff, I don't claim tactical expertise, so I'll have to defer to others. But what he describes mostly strikes me as perfectly reasonable from a tactical perspective as well. So if you haven't seen the channel Active Self-Protection, I would encourage you to at least take a look, decide if it's something for you. I don't usually watch it just because I'm too busy. So I haven't seen the domestic violence situation described here. But there are thousands and thousands and tens of thousands, hundreds of thousands of innocent people, sometimes law enforcement, sometimes bystanders who intervene into domestic violence situations and get jacked up as a result, beaten, maimed, killed, and both parties in the domestic violence situation turn on them. So these are extraordinarily high-risk situations to get into. It's not even like, there's a lot of dangers to coming to the defense of any stranger because there are inherently ambiguities involved in this situation. What's really happening? What's really going on? But at least if it's a stranger on stranger fight, it's unlikely that both those people are going to tell police who respond that you were the problem. If it's a domestic violence type situation and you insert yourself, it's very likely that both those people will ultimately tell the police you were the problem. So if the people, the other side, including the person you're saying you were trying to rescue, is telling the police, the prosecutors, the judge, the jury that you were the problem, you were the unlawful aggressor in that confrontation, what's everybody supposed to conclude? Right? So you're creating a lot of risk and maybe years in prison, especially if you used a gun to intervene. Maybe 10 or 20 years in prison for aggravated assault with a firearm, even if you didn't fire a shot. So extremely, extremely risky. A lot to be said for simply being a good witness. We all carry cameras around with us these days. I don't tell people what to do, so I'm not telling you not to intervene in a domestic violence situation. There's a sheepdog component of the gun community that feels that they're morally obligated to intervene in defense of helpless victims. The sheepdogs have armed themselves, trained themselves, educated themselves. They feel that they have a moral role in society to defend the weak, the vulnerable against violent, aggressive criminals. And I'm not telling anyone not to do that. If that's your worldview, that's for you to decide. You have to make your own decisions about when you're prepared to use or not use force, under what circumstances. All I can tell you is where the legal boundaries are in terms of black letter law and the risks you're likely to be encountering when you engage in that kind of conduct. And if the risks are worth it to you, well, again, I don't tell people what to do. Make your own decisions. But I would prefer that people make those decisions knowing the risks, making an informed decision. That's part of what we try to do at Law Self-Defense. Let's see. Here's another one. Megan K. Thank you, Megan, for your super chat contribution. Let's see. How does Barisone's not guilty insanity impact the civil suit? I assume Kanarek has no suit now. No, she could still have a suit. Interestingly enough, he can have a suit. Barisone could have a suit against them for intentional infliction of emotional distress. So I'm not sure what is going on with the civil suit now, but the fact that they didn't prove the shooting wasn't self-defense, right? Because self-defense was taken off the table. And just because you're found not guilty of criminal liability because of insanity purposes doesn't mean you're not civilly liable for that offense. So the successful application of insanity to Kanarek may complicate the civil waters. I don't really do civil work, but I would not expect it to be some kind of absolute prohibition. Even an acquittal, an outright acquittal, is not a prohibition on a civil suit, right? We all know O.J. Simpson was acquitted for killing Nicole Simpson in criminal court and then later successfully sued in civil court. And he didn't get an outright acquittal, right? It was acquittal by reason of insanity. So he did it, but we're not holding him criminally liable. That doesn't mean that would apply in a civil liability context, when even an outright acquittal on some of the charges doesn't clear him from civil liability. So I don't think there may be some nuanced impact on any civil suit by Kanarek, but I would not presume it takes Kanarek's civil suit off the table. But I would be surprised if there was not a countersuit by Barisone against Kanarek based on this conduct that she conceded to on the witness stand, on direct and cross testimony during the criminal trial here. Okay, let me take another quick look at the super chats and see if there's. I think I hit them all. And I hit some bonus content too, so not just the Barisone trial. So thanks all of you for joining me for this. There is another trial coming up. I'm going to double check when I sign off here. It's the Hannah Payne trial. So for those who don't know, Hannah Payne was another citizen's arrest type situation in Georgia that occurred when Georgia still had its old citizen's arrest law, the same one that was applied in the Arbery trial of the McMichaels and Roddy Bryan, where that citizen's arrest law, I would argue, was given to the jury in ambiguous form. So the judge in the Arbery case failed to do his job and define the law for the jury. He just left it ambiguous, let the jury define the law for themselves, which is not how it's supposed to work. The judge is supposed to define the law, for better or worse, in a way that the appellate courts might agree with later down the road or not agree with later down the road, but it's the judge's job to define the law. And then the jury is supposed to apply the law as the judge defined it. Well, this woman, Hannah Payne, observed the victim, who she would end up shooting and killing. By the way, Hannah Payne is white. The victim is black male. So, of course, we have those political dynamics. It shouldn't matter, but that's the world we live in. She apparently observed the victim, the driver of a car, have a minor traffic collision with another vehicle and then flee the scene of the minor traffic collision. Hannah Payne was driving her own car, pursued this black male, called 911, told 911 she was in pursuit of someone she'd seen flee from an accident. 911 apparently told her they didn't want her pursuing, but strictly speaking, 911 doesn't give orders. So Hannah's free to continue making her own decisions. She managed to get herself in a position where she had stopped the black male driving the other vehicle, ordered him out of his car. He refused. She went back to her own vehicle, got a gun, came back, and in the course of those events, she ended up shooting and killing him. So she's essentially justifying this as a citizen's arrest under the old Georgia citizen's arrest law, which has since been repealed, and then some form of self-defense for the actual firing and the shots herself. The difficulty is if the citizen's arrest doesn't justify the initial pursuit and threat of force, it certainly would not by itself justify the use of deadly defensive force. There's no place in the United States where you're privileged to use deadly force to execute a citizen's arrest. You may be able to use non-deadly force for a citizen's arrest, and you may be armed while making a citizen's arrest, and you're still privileged to use those arms in self-defense if you face an imminent deadly force threat, but you're not allowed to use the gun to enforce the citizen's arrest itself. You can use the gun if there's a threat to innocent persons, such as yourself, but not to affect the citizen's arrest. So a gun can be present lawfully. You could have armed yourself lawfully, so you could be in a position to protect yourself if the citizen's arrest goes wrong. But if you're using threats of deadly force to affect the citizen's arrest, it's no longer a lawful citizen's arrest. And then, of course, you would need some independent justification for that threat or use of deadly defensive force. Frankly, I see Hannah Payne's justification here. Again, so far, I've only seen news reports. This hasn't gone to trial yet. But the news reports make it seem pretty sketchy. Of course, the news reports make every use of force seem pretty sketchy. So you really can't give him any credence at all. I guess I should stop that. So my inclination is, if I'm not already committed to something else during the course of the Hannah Payne trial, I would cover the Hannah Payne trial. It's a use of force case, I think, of sufficient interest to the community that it would be worth covering. Unfortunately, I believe the last thing I read was that it had been delayed to June 6th. It's been delayed repeatedly. All this happened several years ago now. That it was again delayed to June 6th, and I won't be available that week to cover a trial at all. I'll be traveling. If I'm wrong about that, if the date, someone in the comments here today mentioned the date was earlier than June 6th. And again, if it is earlier, if I have the date wrong and the trial actually occurs during a period when I'm in the office, then I would be happy to cover it. And I will cover it. But it all depends upon that timing, which obviously I have no control over. All right, folks, I just want to remind everybody one more time before I go about this weekend's Law Self-Defense Hard to Convict webinar. We have a series of these over the course of this month and next month in May. These are 100% free webinars. We don't charge a penny for them. They are intended to help guide you on the path from being easy to convict, if you're compelled to use force in defense of yourself or your family or your property, to being hard to convict. And we can make you extremely hard to convict. We'd like to show you how to make that transformation for yourself. With our guidance, we can make it a lot easier than you might imagine to make yourself genuinely hard to convict. And this less than 2-hour webinar is intended to show you that path. And as part of that, we'll bust a bunch of common self-defense law myths that people believe because they've seen them repeated 1,000 times, because their local CCW course taught them this. Firearms instructors taught them this. The retired cop down the street told them this. They read it in a internet gun forum someplace, and it's all BS. It's all bad information. It's the kind of myths that, if followed, would be a fast track to a long sentence in a prison cage. We don't want that for you. We don't want you to be easy to convict. We want you to be hard to convict. And we cover that journey, that transformation from easy to hard to convict in these hard to convict webinars. Now, again, they're 100% free. But there are only 100 seats each, and they sell out every webinar. Folks, sell out is the wrong word because we don't sell the seats. It's free, but they fill up every webinar. We have one coming up this Saturday is the next one at 2 p.m. Eastern Time, noon Mountain Time, which is where I am. They're all live, but done over Zoom. And the seats are free, but there's only 100. And once they fill up, they fill up. And I think we have a handful left for the Saturdays, and then there's later dates on the sign-up page. So I would encourage you, if you'd like to be hard to convict, this is a great way to learn how to do that. And you can reserve a seat at lawofselfdefense.com/hard to convict. There'll be a number of dates of upcoming hard to convict webinars there. If a date is displayed, there's still seats available. So go ahead and sign up for that. Once the webinar fills up, the date comes off that sign-up page. So it's full, so there's no more room. Again, you can sign up for that 100% free Hard to Convict webinar at lawofselfdefense.com/hard to convict. And the next one is this Saturday. So I would encourage you to take advantage of that situation. Why a 100-seat limit? Well, Zoom has these tiers of membership that tops you off at certain seat capacities. And if you don't want to pay for the 500-seat license, you pay for the 100-seat license. So that's how that works. Let's see. Use of force or no. Would love to see you on Rekieta more often. You're his best guest. Well, that's very kind of you to say that. He has a lot of great guests on his show. And Nick welcomes me to his show anytime I suggest I'd be interested in coming on. There's no barrier there. It's just my personal focus is use of force cases, and there's a lot of that to cover. just in my own wheelhouse. And so my opportunities of free time to hop over to Nick's channel are limited if it's not a use of force type of case we're talking about. That said, I have a lot of fun over there. Nick's fun to hang out with. The community is fun. So I'm happy to do it when time allows. So that's much appreciated. Let's see. Let's buy Andrew a 500 seat license. Yeah, go ahead. Let's do that. That would be awesome. I'd love to have 500 people a piece in these webinars. We'll see. I mean, if they sell out, I mean, part of the problem is part of the webinar is a live Q&A. We cover a ton of stuff. It's a fire hose of insight into use of force law. And there's always a lot of questions at the end. And I want to be able to adequately handle the questions for the people present without being there for 8 hours. So, another argument for limiting it to 100 is I can handle the questions that come in from 100 people and still do the entire webinar in something less than 2 hours, which is really our goal, our promise to ourselves, and frankly, to all the people in the webinar. I mean, it's a Saturday. Presumably people have stuff they'd like to do. Other webinars are on Wednesdays, but 2 hours is a pretty long time to listen to a lawyer talk about use of force law. All right, folks, I think that's all I have for all of us today. It's about 1 hour and 51 minutes we've been going. That seems like a reasonably lengthy show. Thank you again, all of you, for joining me. I can't tell you how much I appreciate it. And as always, I'll remind all of you, if you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.